CMPD officers who shot and killed a man while attempting to serve a warrant will not be charged. Back in March, 4 officers arrived on Headquarters Farm Road in an attempt to serve a warrant to Reggie Knight for a slew of felony charges. The DA says that when they knocked on the door, Knight ignored officers' commands and instead attempted to run to a neighbor's home. Officials say while running, Knight shot in the direction of 2 of the officers, who eventually returned fire, killing Knight. Now, the officers were hospitalized with non-life-threatening injuries. Yesterday, the DA announced the state will not pursue criminal charges related to Knight's death. We want to bring in our chief legal analyst, Khalif Rhodes, here with us. Khalif, can you tell us a little bit about the process, about when they're looking at a case, how will the DA's office decide?
The standard is pretty straightforward. The DA's office has to look at these cases from two portions. First of all, you have the qualified immunity portion that's there. That's not case law, but that's something that the courts have added as an additional burden or barrier that law enforcement officers will have to be able to be held to. Say if it was me and you involved in some type of shooting, the standard would be lower. That qualified immunity makes you have to jump over a number of things to be able to bring criminal process or civil type of claim against them. And so we'll start with the process in terms of what the DA's office is looking for. In law school, they teach you about this reasonable person, the reasonable, prudent person. That's not you or me, but that's like the perfect, ideal person. And so under that standard, you ask the question, what would a reasonable, prudent person do in the officer situation based on those facts? Would they have believed that they were in imminent fear of bodily harm, or do they believe that their other partners were in imminent fear of bodily harm? And that's what the DA says. He says under these circumstances, a reasonable police officer, that reasonable person, would justifiably believe that they or their fellow officers were in imminent danger of great bodily harm or death. Once you meet that standard, then it's justifiable. Yes, we're talking about loss of life. Yes, a person was killed in this situation. So the question is not did they do it, but was the incident justified? Was their actions justifiable? And the DA's office here is saying that their actions was justifiable. So from the criminal standpoint, that portion is shut. But now the family obviously could go forward with some type of civil process, but typically they'll walk through this same standard.
So if we see any follow-up of kind of a civil lawsuit, about how long does that process usually take? Or is there a standard for when a civil suit might come up? There's
no standard, but I can say this, the baseline is forever. You know, it can take, a couple months to a couple years. Typically, you're looking at years. A family would get some type of investigatory process started. They'll retain legal counsel. Counsel will reach out to a city. They'll reach out to law enforcement, and they will be seeking some type of negotiated settlement. Oftentimes, the city or county will come back and reject or accept the settlement if it's a rejection. If they're like, you know what, we're just going to refuse and we can't, we're miles apart in terms of our settlement, then they'll file a claim. The family will file a claim, and in the process of filing that claim, they'll have to go through that same standard again. Was the officer's actions justified? Did they at some point feel like they were in imminent fear of bodily harm? Are you able to jump over that qualified immunity to be able to bring some type of claim to court? Because if you can't get past qualified immunity, your claim is stopped at the front door.
So when you're looking at cases, are there any kind of particular factors that you might watch out for, in which case you think that one case might have a little bit more legwork to do than another? I mean, for example, it was just earlier, or I guess end of last month, technically, that Mecklenburg County did find an officer who was involved in a shooting liable for murder. So what kind of the differences in the circumstances with the DA's office or any other?
Circumstances matter, facts matter. I tell clients all the time, I don't create the facts. You bring the facts to me, and then I just work with the facts that are presented to me. So in a situation like this, where the officers are saying that the individual shot at them while they were pursuing them, that would be a red flag to me in terms of representation, because you're saying now this person was putting the officers in imminent fear of bodily harm. I'll contrast that with another case that was most recently filed. They tried qualified immunity. The court said no, qualified immunity won't work, and they're going to go to trial in the next couple of months. In that case, the officers were trying to stop a person in the vehicle. The vehicle had passed the officers. As the vehicle passed, officers then started to fire at the vehicle. There's no imminent fear of bodily harm because the car's already passed you. Now, in that scenario, if the officers would have fired at the car while it was coming at them, yeah, imminent fear. But if the car is already passed, the threat's now gone, no reasonable person would believe that they're in imminent fear of bodily harm from a car that's already passed them. That's the facts clearly matter in this scenario. And so it's always fact specific, but if you're evaluating these cases, that's what you're looking for. You're seeing if the facts can be something that will help or hurt your case.
Sure. Chief Legal Analyst Cleve Rhodes, thanks so much for your perspective on that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.